Good afternoon, everyone, and welcome to this week's webinar, where our topic is Estate Planning 101, the key foundations for starting, updating, and protecting your wishes. Now, today's presentation is being presented by the Estate and Asset Protection Law Firm, and I will be one of your two presenters today. My name is Shannon Pauley, and I'll tell you a little bit more about myself in a few moments here. But I do want to emphasize that this presentation we're doing today is being presented for educational purposes only. Nothing we state today should be used as legal advice. The reason why is most of these concepts we're going to be presenting within today's presentation, they're very fact specific to individuals. Further, as with any other area of public policy or law, these are areas of frequent change. So if there's anything we talk about today that catches your attention, you want to learn more about, I encourage you to seek out the advice of an experienced estate planning and wealth protection attorney regarding your particular circumstances. As a matter of fact, for attending today's webinar, we will be extending to you an opportunity to have a complimentary, no cost to you, 15-minute strategy session with one of my non-attorney team members. More information about that to come. Now, as stated, my name is Shannon Pauley. I'm the CEO and owner of the Estate and Asset Protection Law Firm. A little bit about myself here. I am a dual state licensed attorney, both the states of Michigan as well as Georgia. In addition to having a Juris Doctorate, I also do have a Master's of Law in Tax. Based upon my own personal family history in regards to veteran and military service, I'm very happy to say I have been an accredited attorney with the VA, and I can represent veterans before the Veterans Administration. And over my 27 years of experience as an attorney, I basically focused in 5 main areas: estate planning, tax planning, probate, elder law, creditor rights. And I will have to say that the passion for this area of law definitely started back in high school and college, where I was a nursing home volunteer. And the validation that I'm in the right field definitely was further emphasized where I was a daughter as well as a family caregiver for my mother till her recent transition last July from advanced vascular dementia. So that's a little bit about myself. Let me let Ryan do a quick introduction about himself and what his inspiration is for both being with my firm, but also presenting with us today.
Thank you, Shannon. So my name is Ryan. I'm one of the non-attorney team members here at the firm. My official title is what we call a client engagement facilitator. It's really just a fancy way of saying that I am with our clients throughout the entire journey, both before and after. I do a lot of public presentations with Shannon, like today. And I'm really just trying to make myself open and available to anyone who's interested in learning about what we do here at the firm. In my own personal situations, both with family that planned for matters that unfortunately will happen to everyone at some point, both during life and after, led me kind of to this journey. So I saw people who did it, and I saw the ones who didn't, and that led me here. So thanks, Shannon, for letting me be part of the team in the presentation today.
We're very happy to have you here, Ryan. So Ryan, why don't you tell our audience a little bit about our firm's mission?
Absolutely. Well, our mission here at the firm is really just to protect people's legacies that they've worked a lifetime for, to protect it for themselves and the ones that they want to benefit from it when they no longer can. We believe that everyone deserves to be carried with grace and dignity. And our estate planning is done to ensure that the solace and security that we believe everyone should have is done through strategically crafted planning. Everything we do is very personalized to reflect their voice. And you're going to hear us say your voice pretty often throughout this presentation because your voice is powerful. And when you no longer have that voice, both during incapacitation, but also in death, you can still maintain that voice, even if you're not here to physically vocalize it yourself.
And that's why we do emphasize that in our firm's vision, we believe that no one should lose everything, their independence, dignity, grace, assets, when their mind or body starts to decline. Through our advocacy as estate planning attorneys and strategists, through your written documents, we're ensuring that you'll always maintain that level of dignity, independence, and intention through your documents when you can no longer vocalize it yourself, because everyone deserves to live a life of significance till their last breath. Now, How do we live up to our mission that we have, Ryan?
Well, it really starts by listening. We need to understand what exactly the goal is and what kind of planning that we're going to be doing. And we do that by listening to our clients' goals, what their needs are, identifying their loved ones, who's important to them, what's important to them, and ultimately coming up with something that fits that. But we also do by educating. Education is a very, very important factor here at the firm, which is an essential role for all of us here. But we want to make sure that we're with you every step of the way throughout this journey. And we also do it by public presentations like today, or even in-person sessions, and even one-on-one sessions. Then, of course, we prepare a solid plan that's derived around their self-guided choices, because, again, we want to make sure we're reflecting your voice in these documents. These documents aren't just pieces of paper. And to ensure that they're done exactly the way that you want, we need to know what you would like to do. And we do that to preserve independence and protect assets as much as possible. Independence is the biggest focus for us in our mission, because we believe everyone should maintain their level of independence throughout incapacitation as well.
So there could be a multitude of reasons why you're here today. Perhaps you're afraid of what you don't know. We hear this one quite often. Or perhaps you're afraid of missing the boat because friends or family have already started their estate planning journey. Now, this third bullet is one that Ryan hears all the time. And what is that, Ryan?
I want to make things as easy as possible. I don't want to be a burden.
And one of the things I emphasize, and you're going to hear this as we keep moving forward, to make it as easy as possible and as simple as possible. That doesn't mean less pages, my friends. That actually means more pages, because you're detailing out not only your plan, but contingencies in the event life happens differently than what we want it to be in our perfect world. Now, a lot of times also they tell me that they want to be proactively prepared for whatever life may provide to them or throw at them. Or I've got people that still may be in the audience today that you've already started your estate planning journey, and you just want to confirm that you're still on the right course for your journey with where you are today. Now, regardless of what the catalyst was for you joining us today, I do want to welcome everyone. And Ryan, what are we going to learn today?
We're going to talk about what are the 3 essential estate planning documents that everyone over the age of 18 should have. What are some of the positive effects of having each of these documents? And unfortunately, what are some of the negatives of not having any or all of these documents?
So, very important topics here. We've got a lot to cover over the next 52 minutes. So let's start with that first essential document, the financial power of attorney. So Ryan, can you give me kind of like a definitional explanation of what a financial power of attorney is?
Sure. So a financial power of attorney allows someone to appoint another person that's known as an agent to handle their financial affairs, their stuff. So this can include like contractual obligations and actions. They can make financial decisions on someone's behalf if they're incapable of doing so, and just overall help them financially when they're no longer able to.
Okay. And let's talk about some of those common permissions that can be granted through a financial power of attorney, because as we want to emphasize to everyone in the audience today, when it comes to a financial power of attorney, the only powers that your agent has are those that you specifically grant. So what are some of the common designated authorities granted to agents, Ryan?
One of them is the ability to legally access your financial accounts. And we hear pretty often where, well, Ryan, Shannon, my mom put me on her bank account. So, I'm a joint owner on her bank account, so I'm good. And well, that is being proactive. That can be good in some senses here, but realize that doesn't give you access to all of her bank accounts and other financial accounts. So the financial power of attorney can go well beyond just being limited to that one conglomerate.
There's also the ability to be able to pay bills. Believe it or not, guys, just because you want to pay money to a creditor doesn't mean they're going to take it. And in most cases, they probably won't, because creditors, they protect their clients' information with the same vigor and zeal as healthcare individuals do under HIPAA. So just because you know that Mom's mortgage is at Wells Fargo. You don't know the mortgage number, but you want to pay the mortgage. Wells Fargo probably won't even acknowledge that they have a relationship with your mom, for example. Now, another great thing is the ability to enter into and to terminate contracts. And these are very, very important authorities. And why? Can you give some examples of why it's important that your agent be able to enter into and terminate contracts on your behalf, Ryan?
Sure. So enter into, we see this pretty commonly. I actually spoke with someone recently that had an issue with this, where if you have a loved one or are this person that's having a medical emergency where you're in a hospital and you could be unresponsive or you could be not cognitively there any longer, and loved ones could be faced with moving you to a rehabilitation center in order to start stabilizing you. Well, if the best rehab in Metro Atlanta opened up and they want to move you to that facility, the doctors are going to come to that loved one and they're going to say, hey, we got great news. We have a rehab bed that just opened up. We got to act quickly to get them over there. So we need you to sign all these papers to get them over there. Well, families don't oftentimes realize that hidden in that paperwork in 2, maybe even 3 different places, they could be potentially holding themselves liable for your debt. So that's a big risk. And terminating contracts, I like to oftentimes use the example of like cable. I think it's personally easier to walk out of a Disney timeshare presentation than it is to get out of cable. For those who've ever tried to cancel cable, it takes forever. If you're the account holder, it takes forever. So imagine if someone who doesn't have legal authority tries to call and cancel that to get like life-sustaining medication, because cable's expensive. It can be $200 or $300 a month. Number one, they probably won't talk to your loved ones, but even if they do, let's say hypothetically they do, well, they still don't have the authority to cancel the cable. They're not the account holder. So that's a big problem.
And I know one of the things that I love so much when we're talking about giving your agent the authority to enter into and get out of contracts for the individual who's the principal here. I also tell people this is also the authority to enter into contracts on your behalf. This is where you're protecting your agent, where you're making sure that when they're protecting you, you're protecting them by making sure that everything they do is in that fiduciary status. Now, another common power that's granted through financial power of attorney is the ability to actively participate in asset preservation strategies for long-term care. Realize there's different strategies, a creation of trust, gifting, loaning, changing beneficiaries, moving accounts, and et cetera. These are all powers that we've got to make sure your agent is able to participate with an attorney, an elder care attorney like us here at the Estate and Asset Protection Law Firm, because when we're doing long-term care strategy, very seldom are we having that strategy with the person that needs the care. Very often it's the family members who are serving as their agents, and we've got to make sure they have the right powers. Now, if you become incapacitated without a financial power of attorney, we've already talked about many of these risks, but what type of risk could occur, Ryan?
Well, one of them is loved ones possess no legal authority to stop financial hemorrhaging. Remember the cable bill that we talked about? As an example, loved ones possess no legal authority to manage your personal and financial assets. This includes bank accounts and even investment accounts. Loved ones may also become individually liable when signing for documents to get you care that you need, because they're not signing in their fiduciary capacity. They're signing in their individual name. And loved ones may not be able to strategize with an attorney for asset protection and long-term care needs.
And that's where I emphasize it's very important that when you're creating these 3 essential documents, the first one we're talking about right now, the financial power of attorney, you want to make sure that this document that's being created is giving all of the power and the authority to your agent that could potentially be needed so they can probably advocate for you. An important thing to realize, which you're going to hear us state again, is just because you're granting powers to an agent doesn't mean you're giving up your authority to have those same powers. Mm-hmm. Your decision will always trump over your agent as long as you have capacity. Now, when we start talking about these powers of attorney, very often financial, a lot of people get a little confused about what's a general versus a limited power of attorney. So Ryan, can you talk a little bit about a general, and I'll talk a little bit about the limited power of attorney?
Sure. So a general power of attorney is much like what we draft here at the firm. And they're broad. We consider them to be broadly specific. They're not broad enough to where they're very vague, but they're not specific enough to where they're so restricted where you got to fine comb it to figure out what exactly it says. But they don't have a limit in terms of how long they last. And the powers, again, can be broad. So you're kind of covering a vast majority of financial situations for the principal's behalf.
And when you come to a limited power of attorney, I can often use this example with my own personal experience of having to use limited power of attorney. The thing with a limited power of attorney is limited as to the time, is limited as to the use, it is limited as to who can act. So for example, when we first moved down here, my husband and I, to Georgia, we decided to have a home constructed for us. And if anybody's ever had constructions, the estimate that they give you for completion is very seldom dramatically off from the reality that happens. And in our case, constructions will be completed in June, allegedly. But by the time that we were ready to close on the home, that wasn't until like late September, early October. And unfortunately, we had already planned international travel at that time, my husband and I. So when we realized the closing, I wasn't going to give up my vacation. So I drafted a limited power of attorney. It was limited to the specific date of closing between the hours of 8 a.m. to 5 p.m. that could only be used for any document needing signing at the closing attorney's address. I was granting this power limited to my real estate agent, and it was solely for the purposes of signing documentation for the closing of our house that was at that specific address. As you see, very limited as to who could do it, how long they have to do it, what they're allowed to do. These limited powers of attorney, a lot of times people get a little confused that they may have a limited power of attorney and think that they have a general. But if there's ever any question, it's better to get confirmation from an attorney than, as the Las Vegas term goes, let it ride. Because only thing that's going to be ridden, unfortunately, is going to be frustration and aggravation, much like that mechanical bull if it were actually real. Let's talk about the second essential document, the healthcare power of attorney. So if the financial power of attorney is where you're granting to your agent authority over your stuff, your possessions, your contracts, what's the healthcare power of attorney, Ryan?
Well, the healthcare power of attorney is very similar in that the principal appoints someone that they trust, known as an agent, to deal with themselves, their medical side of decisions. So like, for example, the ability to talk with doctors about care decisions and medical decisions. They can participate in consultations. They can access medical records and essentially help you with your healthcare needs in the event that they're not capable of doing so. The medical directive portion is where they're able to explicitly detail your preferred day-to-day and end-of-life medical treatment plans.
Excellent. Now, what are some examples of some powers that can be granted? And don't be surprised, Ryan, if I interject as though I'm a person in the audience as we talk here.
Oh, no worries at all. I expect nothing less from you. So one of them could be the legal access to medical records. That's a really big one. A lot of people think that because they have a HIPAA release, that is substantial enough to kind of fit. And we hear that very often. Ryan, Shannon, I don't need a healthcare power of attorney. I signed a HIPAA release. And the HIPAA release is better to have than nothing. But it's just important to realize that a HIPAA release, number one, is access to historical medical records, not what's currently going on. And number two, it's conglomerate specific. So if you were being treated at Northside Hospital and then somehow ended up at Emory, unfortunately, that HIPAA release would not carry over to that conglomerate. The legal authority to discuss medical treatment plans with your doctors and medical consults. That's another really big one. The legal authority to make healthcare decisions on your behalf. You have to have someone, again, that can legally step in and make those decisions on your behalf. If you're very passionate about having certain medical procedures done or your wishes to be followed, maybe you don't want to have dialysis, maybe you don't want to be resuscitated. Those are important things to have in writing so that we know how to help take care of you.
Well, Ryan, I have a question for you, though. We've had situations where we've had clients that come up and they think that we're at times trying to bamboozle them with this because they'll tell us about some family member that they were dealing with in a hospital, that nobody had these healthcare powers of attorney. And the doctor actually talked to them, interacted with them, gave them updates, asked for their input, gave them statuses. And because they had that experience, they conclude that there's really no need for a healthcare power of attorney. How would you respond to that?
I always respond by saying, because that is a common thing that we get, but realize that is a one-off situation. Number one, that medical staff are not obligated or required to give anyone who doesn't have legal authority any information under HIPAA. So while they may have had that one experience, that one off, realize that medical staff can throw their hand up in front of them for any reason at any point, and there's nothing that they can do to override that. And because even though they weren't following protocol before with HIPAA, well, now it's, oh, that's a HIPAA violation, I can't tell you. No, that's HIPAA, I can't tell you. And they could have had a bad day. They could have woke up late. They could have spilled coffee on their brand new lab coat, and that completely changed their entire outlook on the whole situation. So it's just another roadblock that, unfortunately, you don't want to gamble on.
And I agree on that because, yes, there are occasions where doctors interact when they shouldn't under HIPAA. But the issue is, once the doctor says no, the medical staff says no, there's no legal standing to challenge that unless you go through the courts with guardianship and conservatorship. To me, it's a high risk. And that's why I would rather have the documentation in place to grant my loved one's legal authority instead of on a hope and a prayer that I have a loose-lipped doctor or medical staff. Mm-hmm. Now, the last really big thing that the healthcare power of attorney can do is that when it appoints your agent, that person is actually going to become your healthcare advocate. And they're going to ensure by standing up to doctors, discussing with doctors, and insisting upon doctors and other medical personnel that your wishes are both understood and followed. This is why I very often make the comment when it comes to that healthcare power of attorney, you don't want Meek Mary to be serving in this role. Meek Mary is not going to be able to stand up to make sure that what you have instructed her to ensure occurs does. But you do want bold Barbara. Bold Barbara is going to be the one that gets to the doctor and the medical staff says, absolutely not. This is what she says specifically here she does not want or that she does want. Be observant of that too, my friends, as when you're granting these powers, realize by granting these powers, you're creating your agent to become your advocate for you. Now, within a healthcare power of attorney with medical directive, there's a terminal medical directive portion. And I personally am of the position this is the kindest gift you can give to a loved one. There may be people in the audience today that unfortunately they had to make that final decision without any guidance from your loved one as to whether or not to keep them on a machine, take them off the machine, to change their medical treatment when they're in a terminal condition. And to those people who have had that experience, first of all, my heart goes out to you because we've had many clients and loved ones of clients come to us expressing the lifetime of guilt they have. Did they take the person off the machine too early? Did they leave them on too late? What do you mean that there was a experimental medication? If only I would have known that, I would have done that. Or, oh my God, I put them on experimental medication and unfortunately they hit every single one of the side effects. So I wasn't saving them, I was tormenting them. Here's my comment. It's important that you as the principal, you make these decisions now. And trust me, this will be some of the hardest decisions you're going to make in an estate planning attorney's office. Mm-hmm. But it's better that you take on that burden and you state what you want because that's where you are going to take the weight off the shoulders of your loved ones. Now, that doesn't mean just because you've declared how you want your medical treatment plan to be in a medical terminal condition, that doesn't mean that's going to be easier for them to say it. It's still going to be hard to say, take mom or dad off the machine, for example. But they're honoring you at that point, and you've taken that lifetime of second guessing and regret off their shoulders. That's why ensuring you complete that terminal medical directive is the kindest gift you can give a loved one. Now, Ryan, what's the risk that could happen if you become incapacitated without a healthcare power of attorney?
Well, as we stated, I mean, if you don't have a proper authority to talk with, medical staff, well, you could get shut out of medical decisions and discussions. And loved ones also will be unable to have healthcare updates if you're having a medical emergency due to HIPAA laws. HIPAA is a very, very tough thing to get around with medical conglomerates. And loved ones are unable to ensure that your day-to-day and end-of-life medical wishes are being met and attended by medical staff.
So as we look at these first two essential documents we've talked about thus far, both of these, I want you to realize, members of the audience, these are estate planning documents that have effect during your lifetime. So often we talk to people about estate planning, they think it all has to deal with when you die and thereafter. But estate planning is not only making sure that your legacy is preserved, it's also ensuring that you live a life of significance, the life fullest as it can be pursuant to your instructions. And like we said, that financial power of attorney is over your stuff, your contracts, and the healthcare power of attorney is over you as an individual. Now, there have been some occasions in the news where we start hearing about something similar to powers of attorney, but it's when the courts get involved, and it's called guardianship and conservatorship. We've heard about this with Britney Spears, Wendy Williams, and a multitude of other famous individuals. So what I'd like, if you don't mind, Ryan, let's talk about the difference between a power of attorney and guardianship and conservatorship. And if you could do the powers of attorney, I'll address guardianship and conservatorship. How's that sound?
Sounds good.
Okay, so why don't you start out with powers of attorney here?
So powers of attorney are a voluntary act from someone who has the competency to grant the authorities in a power of attorney. So the agent that person appoints in their power of attorney is accountable to no one other than them. And they have what's known as a duty of obedience. When we say duty of obedience, that doesn't mean that they can do what's in the principal's best interest. They can only perform actions that power of attorney specifically states they can do. So they can't just go out of their way again and make their own decisions for them. So an individual that does grant these powers can also revoke them, provided that they have the competency at time of revocation. But it also preserves your autonomy because your voice guides you and guides your loved ones in situations where you might need some assistance. Remember how we said your voice is impactful and it's important to preserve? This is going to help you preserve that. And some of the benefits are, number one, you retain your power, to reiterate what Attorney Pauly stated earlier, that you're not giving up any power provided that you have capacity, but they're also a heck of a lot more convenient, and as we're going to find out, a heck of a lot cheaper too.
100%. So let's talk a little bit about guardianship and conservatorship. So as you see what Ryan was saying, powers of attorney, you have control as the principal of what to grant, who to grant it to, and you can take it away at any time. Well, that's not how it works once we start talking about guardianship and conservatorship. Mm-hmm. So I want you to realize that guardianship and conservatorship, these are involuntary proceedings where the petitioner is petitioning the court to take away the rights of an individual by the court declaring that person legally incompetent. Now, if you go down this path of guardianship conservatorship, number one, you need to realize the court will be involved here. And where the court is involved, there will be a hearing where the court will determine the legal incapacity. And you need to realize that at this hearing and prior to it, the proposed ward or the person you're trying to take the rights away from, they're going to be put on notice, and they will either retain their own legal counsel or legal counsel will be appointed for them from the court. And at this hearing, we're going to have the petitioner who's stating why they believe that the fundamental rights of the individual should be taken away and they should be declared legally incapacitated. Then we're going to have a medical assessment because a medical provider would have done a medical review of the proposed individual to be declared a ward. And then thirdly, the ward and or the ward's attorney, they're also going to have reports and engagement with the judge is determining whether to or not to grant guardianship conservatorship over the proposed ward. Now you need to realize court, they're the sole decider here, not the individual. The court's going to decide whether that petitioner or a third party should be appointed to serve as the guardian conservator over that proposed ward. And now, when that guardian conservator has been appointed, you need to realize, unlike in a power of attorney where they have the duty of obedience, following the instructions and the wishes of the principal, when you deal with guardianship and conservatorship, what the principal wants is no longer of any concern because their whole focus is to act in the best interest of the ward. And one thing I will tell you, best interest of the ward is usually very often keeping them alive. And when you get that title of guardianship or conservatorship, that's not a crown of glory, my friends. That becomes a crown of thorns. Because now when the court is involved in everything. The guardian conservator can be accountable to the court by making regular written reports for status. And there's going to be certain actions that they're going to have to petition the court for permission to do. It becomes a whole game of mother may I. Mother, may I sell the house? Yes, you may. Mother, may I accept this offer to purchase the home? Yes, you may. So what I want you to realize here is there's a lot of burden. There's time burden, financial burden, emotional burden when you're going down the path of guardianship conservatorship. So you may say, why would you ever go down this path? Well, to me, going down the path of guardianship conservatorship, this is a path of last resort. And it should only be sought when the incapacitated person either A, took no proactive steps by trying to get powers of attorney drafted, or when the documents that were drafted are inadequate and did not grant all of the appropriate powers needed to properly advocate for that individual. Now, Ryan, I know that there's been some situations that we'd like to share with our audience that we've seen in our office that illustrates the need for these powers of attorney. So can you talk a little bit more about who we're going to talk about today? And if you could cover the situational facts, I will take it one step thereafter and apply the law and the events that happen to those situational facts.
Absolutely. And we have plenty of examples that we can discuss about some situations that we've seen, but the three that we're going to talk about today are related to an individual that we'll call Ben, Sarah, and Clarence. Now, Ben was he's no longer here, but Ben was 20 years old at this time when we got involved with this. And he was a college student that was entering his final semester in college. And like many 20-year-olds, he wanted some independence. So he moved out of his parents' home and got his own apartment in his individual name. He signed the lease. And while he was there getting ready to start his semester, he suffered an acute psychotic breakdown associated with a diagnosis of bipolar schizophrenia. When he had that breakdown, he was living independently. And as a result of his condition, he was involuntarily committed to a residential treatment program to kind of help stabilize him. And unfortunately, he did not have any estate planning documents. And there's a reason. Ben is a good example of why we say that these documents are for anyone over the age of 18. Because after you're at that age, you're considered a legal adult. And in the eyes of the law, no one can make decisions for you anymore. And we think about our children going to college and we get them, the car checked, we get them a credit card, make sure it's good to go, the phone bill's all good, whatever they need to go off for school, but we don't think about them being an adult now. So what happened with Ben, Shannon?
Sure. So what you got to realize is because there was no financial power of attorney, first and foremost, Ben's parents, they didn't have the legal authority to challenge the landlord's refusal to allow them entry into his apartment. Like what Ryan stated, that lease was entered into between Ben, a 20-year-old male adult, and the landlord. And while the parents wanted to try to figure out what happened to Ben, they were contacted by a neighbor, but still, maybe there were some clues as to what happened in the home. They had no authority to enter the apartment. And if you remember, we taught this at the beginning of a semester. And if anybody's ever attended any type of like college, university, and sometimes even trade schools, if you cancel the classes within a matter of days of the start of the semester, you can usually get a full or a partial refund. And unfortunately, Ben's parents had no authority to cancel his classes, to stop those student loans going through and him incurring a semester's worth of tuition when he couldn't attend. Now, because there was no healthcare power of attorney, first of all, you need to realize that the parents, even though there was a neighbor that said he believed he had overheard that Ben had gone to one specific residential facility for stabilization and treatment, parents couldn't confirm that he was there. And the reason he couldn't confirm is because if you contact a residential program, even if you're asking the question, hey, is John Doe there receiving treatment? They're not going to confirm he's receiving treatment there because that's a HIPAA violation. So not only could they not confirm where he was at, they also could not have no discussions with the doctors to confirm what's his status, what's the treatment, what's the future that they're anticipating to occur. Unfortunately, they could not advocate in any way for their son, nor receive any medical information. So unfortunately, until ultimately he was stabilized and was able to contact his parents, parents were in a fearful state of just confusion and non-information. Can you guarantee you? I remember when I was 20 years old, if I went through this, I'd want my parents there. But unfortunately, much like Ben, when I was 20, I didn't have powers of attorney. And unfortunately, my parents would have gone through this same chaotic experience, which I'm happy that they didn't. And hopefully by us giving this example of Ben, you'll realize the importance of why, like Ryan stated, the need for these documents starts at age 18.
So next we have Sarah. And I think Sarah's case is very interesting. Sarah is everyone's golden child. She's done everything right. She's 34 years old. Her mother considered her the responsible, accomplished adult because she did everything right. She had a very strong career. She owned her own home, and she's building a real estate empire, essentially. She had 6 rental properties and accumulated several hundreds of thousands of dollars in investments through planning and discipline. And that's not including the property ownership that she had. Now, despite her success and independence, Sarah experienced some swelling on the brain, unfortunately, that did leave her in a comatose state. And very similar to Ben, unfortunately, she did not have any estate planning documents.
And you're going to see some repeated themes here about family members being shut out. But here, because there's no financial power of attorney, Sarah's mom, she was basically financially paralyzed. She was unable to access the accounts to ensure the mortgages were paid. And further, she couldn't even collect the rental payments from the tenants because, one, they had no idea who she was. But even if she did collect them, she had no ability to even deposit those checks into her accounts because she had no legal authority to access her financial accounts. Now, because there's no healthcare power of attorney, number one, we're dealing with a 34-year-old adult female. So in the eyes of the law, she's an adult. And Sarah's mom was essentially shut out of most of the critical medical information. And further, this was a scary experience for Sarah's mom because it was touch and go for a while. And there was a point where she was thinking she was going to have to make very difficult decisions concerning the medical interventions to prolong Sarah's life. And this was conversations that they'd never had before. Because unfortunately, in Western culture, death is so taboo. Families don't discuss it to know exactly how they would want life-sustaining treatment when they're in the final stages of a terminal illness or the final stages of life. Luckily, Sarah did come out of this. Her and her mom are big proponents for the need for these documents. But unfortunately, for them to get the knowledge, they had to go through the suffering. And us sharing their stories, hoping to prevent other loved ones from suffering similar to Sarah's mom did.
And certainly, and I think Sarah and her mother had, of course, a good happy ending, but I can't unfortunately say the same with Clarence. So Clarence is a 55-year-old married professional, and I think that's important to note that he was still working when this happened. And he had a milestone, and we see this very common that, people have milestones and when they're going to do their estate planning. I want to wait till I'm retired. I want to wait till I have children. I want to wait till I buy a house. Whatever that milestone may be, we always like to emphasize that tomorrow is not promised, and you can certainly plan for the unknown. But Clarence, he and his wife, they maintained separate financials. They never commingled their assets because they were a blended family. And for those who aren't familiar with a blended family, think of like the Brady Bunch. So they never commingled their assets. And she ended up selling her home and moving in with Clarence, who owned his own home in his sole name. And along with that, had the mortgage in his individual name. So he unfortunately suffered a heart attack one day and was undergoing routine surgery. And unfortunately, there were some complications that did lead him to be what we call locked in, which is essentially he was unable to speak or move. He was now a quadriplegic, and he could only communicate by blinking his eyes. And he unfortunately did not have any estate planning documents.
Yeah, the whole idea of the milestone, unfortunately, has bitten the bum of more people that have come into us than I like to really accept.
Yeah.
But with Clarence, I mean, this is such a horrible situation. I can't imagine the wife being beside her husband, going to the hospital, being there with him as he's put on that gurney to go have the routine surgery. But what comes out is not the husband she was just talking 2 hours before. Let's talk about what happened because of the lack of powers of attorney here. Now, because there's no financial power of attorney, and because the mortgage and all the bank accounts were solely in Clarence's name, unfortunately, his wife was locked out of his finances. She was unable to access accounts to make mortgage payments. So you've got to remember, even if he had it on auto payment, if there's no money coming in, there's no money that could go out for those auto payments. So the wife, she wanted to reach out to the mortgage lender, basically asking for a hardship forbearance based upon all that was going on, but they refused to speak with her. And unfortunately, despite all these efforts she was trying to do to preserve the home, that home ultimately went into foreclosure. And that wasn't because of neglect, but that was because she lacked the authority to act. And then concerning the health care, once again, the man that came out of the operating room was not the same man that went in for her. And unfortunately, she was denied medical access to records because she had no legal authority. And that left her unable to understand exactly what happened, what went wrong. Well, ultimately, we did assist Clarence's wife with getting guardianship and conservatorship over him. And after she had the legal authority to access those medical records, she learned that an improper medication had been administered during the medical procedure. And that ultimately led to the medical malpractice lawsuit that she subsequently filed. And unfortunately, even though they won multi-millions, this isn't a happy ending. That's not a Disney ending, my friends. Why, Ryan?
Well, number one, unfortunately, with him being a quadriplegic now, being at that level of care is expensive. If I'm not mistaken, there's only a couple medical facilities in the state of Georgia that can even accommodate someone who needs that level of care. And it's very, very expensive. So even though they won what could be, $4, $5, $6, $7 million, Clarence is young. He's 55 years old. He could live another 20, 30 years pretty easily. So even though they got all that money, it's going to dwindle fairly quickly over his lifetime to make sure that he gets the quality of care and quality of life that he deserves.
And I can guarantee the family would turn all of that over plus just to get the Clarence that was one day before that heart attack.
Absolutely.
Now, my friends, we're about to start that third essential document, but as we're prepping, hopefully you've learned, at least with these first two, of the significance need, and it may have now started to inspire you to wanting to have communication. And what I want y'all guys to see, remember how I talked about it's going to give y'all guys an opportunity to have a complimentary, no cost to you, 15-minute strategy session with one of my non-attorney team members, such as Ryan. Well, if you look at the right-hand side of your screen where there's a shopping cart, you may see a red dot there under offers. You can go there, hit that green book now button. It'll take you to a screen for available dates and times after you enter in some basic information so you can schedule to your convenience that strategy session. So let's jump to our third essential document now, Ryan. And that third essential document is the will. So what exactly is a will, Ryan?
Well, a will is a legal document that provides details and instructions for the post-death distribution of property that someone had in their individual name at time of death.
Okay. And if you pass away and you don't have a will, well, then you're deemed to have died what's known as intestate. And when this occurs, the court system takes over the responsibility of dividing your assets between your descendants through the probate courts via what's called the laws of intestacy. And as you look at this next screen here, we're giving you some examples of how the laws of intestacy work here in Georgia. And at first glance, you may go, okay, I'm fine with this. I don't want to invest the money in a will because that looks like how I'd want it to be. And you say that until we start applying facts to it. Ryan, can you apply a situational fact to one of these, if you die with, here's what happens scenario, to where it may not be what you want, though on first glance, you may think you want it?
Sure. So I'll kind of start with the top one here, children. So if you die with children but no spouse, under the laws of intestacy, your children would be your legally recognized heirs. And let's say you have two children. Let's say child number one is CEO Cindy. CEO Cindy is much like Sarah. She did everything right her entire life. She's very successful and may have no problem with her receiving her inheritance outright. And that's fine. But then we have alcoholic Al as your second child. Well, alcoholic Al, unfortunately, he's got some demons. And if he's going to set to receive what could be 10, 20, 50, 100, $500,000 because of his demons, unfortunately, what do you think that he's going to do with it? He's probably going to blow it to feed his demons.
And here's another example I'll give you. And I saw this, unfortunately, a lot, both during and after COVID, where we're having situations where children were caring for their parents. And one of the things I will tell you is our clients, the parents in that situation, they came out of lockdown and isolation actually pretty good when they were being cared for by their family members. But those poor caregivers, they came out and they looked like they had spent 10 years in a war zone. And unfortunately, something that we'd seen happen more than once, especially once we had gotten the loved ones onto Medicaid, for example, is where the child was the caregiver for the parent. The child got the parent onto Medicaid. And then, unfortunately, the child passed away. And when they passed away, they had no spouse. They have no children. But their parent was still alive. We're going to call her Medicaid Mary. Well, Medicaid Mary was still alive. And as Medicaid Mary, the mom, was the closest living relative to the child that died, Medicaid Mary would inherit everything directly. And by receiving money directly, and with Medicaid being what's called a means-based tested program, you can't go above a certain amount of income or resources, that inheritance is going to prevent continued eligibility for Medicaid and kick them off of Medicaid. Where if only that caregiver child had done some form of proactive strategy, trust, will, etc., they could have still left the money for mom, Medicaid Mary, but it would have been through such vehicles as a special needs trust due to a testamentary trust language, for example. Now, wills, very familiar. A lot of people have heard of them, but let's talk about what some of the pros are. And don't worry, Ryan, I'll do the negative. I'll be the Debbie Downer. I'll do the cons. So why don't you go right ahead with the pros?
Absolutely. I like making you the Debbie Downer. So there are some pros to having a will. And that's why it's one of those three essential documents, because you get to leave property to those that you choose. And without one, it falls under those laws of intestacy and the court determines who gets what. And nextly, you get to choose your executor. This is a person that you appoint in the will to work through the administration of the estate. So they're going to go through the probate process to distribute your assets with the court. If you don't have an executor or will, they appoint someone that's known as an administrator, and realize an administrator could really be anybody. It could be Alcoholic Al, for example. It could be your nosy neighbor. It could be an attorney. And if an attorney's appointed, guess what? They get paid before your heirs do. And then you can also plan for burial matters and other personal matters like pet care. I know pet care is very important to Attorney Polly's estate plan. You can create what's known as a testamentary trust. So these are trusts that are established through the will in order to protect those that you want to leave things for from either themselves or others. So if you remember our prior example with Medicaid Mary, there are testamentary trust language to protect her, an Alcoholic Al, and even others. You can have one prepared quickly. You can amend them and revoke them, provided that you have the capacity to do so.
And before I start talking about the cons, let's talk about statutorily in the state of Georgia. What are the 3 statutory requirements to have a valid will in the state of Georgia? Number 1, it must be in writing. We don't recognize video wills here in Georgia. It must be in writing. Number 2, it must be signed or affirmatively marked by the testator. And then number 3, it must be witnessed by 2 persons over the age of 14. Now, a lot of people may say, but I thought a will has to be notarized. A will does not have to be notarized. In the state of Georgia, once again, in writing, signed by the testator, witnessed by 2 people over the age of 18. Now, the notarization part is usually what's called a self-proving affidavit. That's at the end of the document. And it's a substitution for subsequent testimony of the witnesses, affirming that when the testator signed, they were not under any type of undue influence, manipulation. They knew what they were doing, and they did it so voluntary. Because if you don't have that self-proving affidavit, which once again is not required to have a valid will, it's just best practices to have it. But if you pass away and you have a valid will but no self-proving affidavit, that just means that when the will is submitted to probate, those witnesses will have to be identified and located so that they can proceed forward with doing testimony to the court stating what they recalled from the date of signing. Want to make it easier? Self-proving affidavits all the way. So now we understand the pros of a will. We understand the requirements for a will here in the state of Georgia. Let's talk about some of the cons here. So, con number 1, a will has no legal effect during your lifetime. During your lifetime, you can call your child your executor, but that child has no authority, and that will has no legal authority because you're alive. Now, for that will to have legal authority, number 1, you must be deceased. Number 2, that original will with an original death certificate has to be submitted to the probate court in the county you resided in at time of death via what's called a petition to probate in solemn form. Number 3, the court will give 30 days usually to allow anybody to object to the will before they'll deem it your last will and testament. And then step 4 is when they are going to grant and recognize the executor in your will via what are called letters testamentary. Until we get to that step 4 of letters testamentary, your executor has no authority or power over your assets. And it is that 4th step, the letters testamentary, where they can finally start acting on behalf of the estate. So that's one con. Has no effect during your lifetime, and even after you die, it is required to go through probate. That's where this whole wives' tale comes from. A lot of people think that a will is a ticket out of probate, but it's not. The deciding factor, if you have to go through probate, is not whether you have a will or not. It's whether you pass away with assets in your individual name. Now, when you go through the probate process, there's several negatives, but one of the big ones I don't like is the lack of privacy, because everything filed in a probate matter is public record, from the will in its entirety to the inventory if required, to annual reports if required, final inventories, orders of the court. That's all public record. There is no privacy through the probate process. And oh yeah, if you own property both in the states of Georgia and another state, you've got double the pleasure, double the fun if you pass away with either no will or just a will, because you have to probate both in the state you resided in at time of death, but you'll have to do separate ancillary probate proceedings or a whole nother probate proceeding in each of those other states where you own real property. And lastly, you need to realize that a will, it doesn't address estate and income tax concerns. So we've just gone over a lot. Ryan, what are those 3 essential documents for everybody over the age of 18?
The first one that we talked about was the financial power of attorney. So that has to do with your stuff, your contractual affairs, your bank accounts, your investment accounts, et cetera. We have the healthcare power of attorney with the Georgia Medical Directive. So this is going to deal with you as a person so that we can help make sure that you're getting the proper medical treatment and care that you want. And number 3, the one that everyone thinks that the only one that we do is a will, is the will. So those are our 3 essential documents.
So at this point, my friends, we are at the conclusion of our presentation. We've got about 5 minutes remaining. So if you have any questions, please don't hesitate to ask those in chat. And as you're prepping to perhaps provide some questions to us to answer over the next 5 minutes, Ryan has a series of questions that he wants to ask you.
So some questions that I would like for you to ask yourself from our presentation today is, if you became incapacitated, do you want to ensure that your loved ones can assist you? Do you want to ensure that the assets that you've spent a lifetime accumulating are distributed to your intended beneficiaries after death? Do you want to protect your assets for others? Do you want to make the transition into disability or even death easier for your family? Do you want to ensure that your wishes or bequests are fulfilled?
And my comment is, if you answered yes to any of those questions, you owe it to yourself to continue your education and your understanding by scheduling that complimentary, no cost to you, 15-minute strategy session by going to the offers tab, hit the book now, enter in basic identification information, and pick a date and time that works best for you. So as I look, Ryan, at this point, I don't see that we have anyone that has asked any questions. So I'll pause for a few more moments just in case somebody's about ready to ask us a question here. And I'm not seeing anything at this time. So my friends, we are now at the conclusion of today's presentation. We're almost at the top of the hour. On behalf of myself and Ryan, we'd like to thank you for attending today. And Ryan, I'll let you have the last word.
Yeah, absolutely. Thank you guys for coming out. It's such a pleasure to have you all, and hopefully we'll get to talk with you soon.
Be well and be safe, everyone. Bye-bye.
Thanks, guys. Bye.